What's up, everybody? Welcome back. This is the Tactical In-Service Podcast. I'm attorney Eric Scramlin, and this is a podcast for law enforcement where I break down case law and training topics to help you stay up on the law. Today, this is an episode for my New Mexico officers. I'm going to be talking about a brand new case out of the New Mexico Supreme Court that makes some pretty big changes to the way you're going to charge and prosecute aggravated fleeing cases under the New Mexico statute. That case is State versus Vest. I'm going to dive in. I'm going to break it down for you. But before I do, let me just remind you really quick. If you haven't subscribed to the podcast, make sure you follow us on whatever app you use to listen to podcasts. And if you're watching this on YouTube, please do me a favor and hit that subscribe button down there. Whenever these cases come out, I try to get these episodes out as quick as I can. I also want to make a quick announcement that coming up here, actually in about a week and a half here on Saturday, June 19th, 2021, I'm going to be doing a live training via webinar for officer prosecuted cases. So if you got to prosecute your own cases, this is going to be an all-day training where I'm going to walk you through step-by-step how to prosecute your own cases in magistrate court or municipal court. So the information is down below, or if you're listening to the podcast, you can go to my website at tacticalattorney.com to get all the information you need there. All right, let's dive right in. So today, like I said, I'm going to be talking about this brand new New Mexico Supreme Court case, State versus Vest. And the citation on that is S-1-SC-37210. Link in the description below if you want to read the whole case, and I encourage you to do so. It's a long opinion. It's about 45 pages, I think. In this 10-minute episode, I'm going to try to get to the important stuff for you, but I still encourage you to read the whole thing. So, all right, State versus Vest. This is a big one. I think you guys are going to like this one. I'm sure you probably already heard some talk going around about this because for the last several years, because of the precedent set, a few years ago by our Court of Appeals, aggravated fleeing cases became pretty tough to charge because even if you had really bad driving, you couldn't charge aggravated fleeing unless someone was actually put at risk. So if you're chasing someone 100 miles per hour down Main Street, blowing through red lights, hopping curves, but there's no pedestrian out and no other traffic, you're stuck with misdemeanor REO. This case fixes that hole in the law. So let's talk about it a little bit. Let's start with the facts of the case, and we'll kind of go from there. So this case happened, I believe it was down in Las Cruces. It was near New Mexico State University. Apparently, the facts are a little bit weird, kind of setting it up, but it doesn't really matter. Apparently, the officer pulls up near campus. It's 3 o'clock in the morning. You have the owner and the defendant sitting in a car. Apparently, they've been smoking weed that night, and they were out looking for more. They're going to meet the defendant's contact, but as luck would have it, as the officer pulled in, the owner of the car, I think he might have been sitting in the passenger seat, gets out and runs up to the police car and says, "Hey, this guy's trying to steal my car, and he just pulled a knife on me." So the officer says, "Okay," and then he sees the brake lights turn on, the car speeds off, according to the opinion. Officer turns his lights on and gives chase. They say that the car sped away. The officer was doing 70 miles per hour down Main Street, and the car was getting way ahead of him. In fact, he even at some point lost sight of the vehicle. The officer says the defendant drives over a bridge, speeds past an apartment complex. The officer's got to slow down at this point, and also mentions that the roads were slippery that night. Okay? The officer loses the guy. Starts looking around for him, finds the car. It had jumped the sidewalk, crashed into a road sign. They bring the dog out, find the defendant down in Arroyo, and he gets convicted at trial of aggravated fleeing. Well, the defense attorney says, "Well, wait a minute. We have the New Mexico Court of Appeals case. We didn't have any evidence that there was anybody actually put at risk, even though we clearly have very bad driving here, and it seems very obvious that he knew that there was an officer behind him with his lights on." So this case goes all the way up to the New Mexico Supreme Court, and they take a look at this, and the issue that the court wanted to decide here was, to charge someone with aggravated fleeing under the New Mexico statute, and what is the statute here? I'm sure you guys know it, but let me give you the number for it. I'm talking about 30-22-1.1 New Mexico statutes annotated. That's the aggravated fleeing statute. So the issue presented to the court here was, does its requirement that the defendant drive in a manner that endangers the life of another require that another person was literally put in danger by the defendant's conduct, or is dangerous driving that places the community at risk of harm enough? That was the issue before the court. And the court held that dangerous driving that poses a risk of endangerment is enough to charge someone with aggravated fleeing. So they overturn the Court of Appeals decision that requires someone actually be put at risk. And they say, now we're just going to focus on the defendant's conduct here. So the previous precedent is now overturned. So what we've been dealing with the last several years on not being able to charge aggravated fleeing unless someone was actually put at risk, the Supreme Court has overturned that. Let me tell you what they focus on now based on this decision. The court, first of all, I think this is a very well-written opinion. It's very long, like I said, like 40-something pages, but it's very thoughtful, and the court goes into great detail in looking at what was the intent of the legislator. Okay, what was the intent of the legislator when they passed this statute? So the court looks at the legislative intent, and they go through and they kind of analyze the words that were used, and the court comes to the conclusion that the intent was to protect the community against the risk of harm posed by high-speed chases. And the defendant, like in this case, should not be rewarded because he was lucky enough that someone just didn't happen to be out there, or there was no other cars out there at 3 o'clock in the morning. And the court uses a great line. I really love it. They said to hold that would lead to injustice and absurdity. And I think a lot of times when you would present cases to your DA, it would seem absurd that you couldn't charge aggravated fleeing based on the defendant's driving just because there wasn't someone actually put at risk. Now the court looks at this and they say that wasn't the intent of the legislator. The legislator clearly intended, because we have REO, a misdemeanor, they intended that this greater offense of aggravated fleeing, which is a felony, when we focus on the defendant's driving, if it endangers the community, we shouldn't let him go because they were lucky enough that someone just didn't happen to be out there. Okay, so what does that mean for you as a police officer? That means we kind of go back to the old way of how we charged it, but I think you really need to look at the case because it's not exactly the old way. The court kind of changes a little bit and they say, hey, focus on the conduct of the defendant and what his driving is like. So the court noted, and I want to cite this is language from the case. The court noted, we interpret the aggravated fleeing statute to require only that a defendant willfully and carelessly drove so dangerously the defendant created a risk of harm, a risk that could have endangered someone in the community. So that tells you what you need to focus on. You're going to want to focus on the defendant's conduct. So willfully. This isn't a specific intent crime, okay? This is just a defendant willfully fleeing the police. Okay, so go back to some of that other case law. Be sure that your cars or your units are marked properly. Be sure the lights are clearly visible. You got to give that signal still. Focus on again, I can't stress enough, focus on the defendant's conduct. Look at the factors like in this case, specifically the court cited in upholding the aggravated flee in this case, the court noted the defendant's speed, which was in excess of 70 miles per hour down Main Street, the road conditions, which were slick that night, the time of day or night. Do they obey the traffic signals? Okay. Are they going over the center line? What part of town are they in? Are they in a busy part of town or a non-busy part of town? And like in this case, they really focused on how he went past that apartment complex. And then again, he jumps the sidewalk and hits a sign. Luckily, there wasn't anybody standing there. But that type of conduct is the type of conduct that would put the community in danger, even though there wasn't anybody out there. That's very dangerous, and it could lead to someone getting seriously hurt. So one more quote from the case here that I think is really important on page 23. The court noted, as we discussed previously, a defendant may be convicted of aggravated fleeing regardless of whether the state can prove that another person was near the scene of the chase. What is significant is not whether there was at least one person in the vicinity of the police chase. Rather, the focus is on whether a defendant drove so dangerously that he could have hurt someone who could have been in the vicinity of the pursuit. The question is whether he put the community at risk of harm when he fled the police. The act of driving in a dangerous manner while fleeing the police is enough to convict the defendant of aggravated fleeing. So that's the court telling you to look for those same factors that you would look for in a careless driving or a reckless driving case. As always, you should check and consult with your local district attorney, your local city attorney, your county attorney on some further guidance on this. If you have any questions, please leave them in the comments down below. Send me an email, escramlin@tacticalattorney.com. And if you have any questions about it, let me know, because this case, although it goes back to kind of the old standard, I think it does leave a few questions out there about, what are the type of factors the court may be looking for now. So good decision. I think it was well written, and it really fixed that hole we had in the law with aggravated fleeing. If you haven't signed up for the podcast yet, let me remind you one more time, follow us, give us a like down there if you're watching it on YouTube, and follow us on there as well. Hey, come to my class on June 19th. I would love to see you there. Got a very limited amount of seating left. So guys, I hope this helps a little bit. Let me know if you have any questions. Remember, every battle is won before it's fought. Stay safe. I will see you next time.